Good evening. Welcome to another episode of Reasonable Doubt. I'm Justin Harris, still sitting in the driver's seat. Everybody hold on. We are brought to you physically by Houston Media Source and Mark Pirtle over there. Thank you all very much. And financially and morally and mentally and spiritually, unfortunately for everyone else, by the Harris County Criminal Lawyers Association. We are continuing on with our saga about Clay Harrell, however he pronounced his name, former assistant district attorney in Galveston County, with Thomas Overhouse and Jessica Ebbs in the murder trial. They got a very quick not guilty on. So this week we're going to kind of try to wrap that story up and then also segue this into like a broader discussion of, prosecutorial misconduct, integrity of public officials, things like that. So I don't know if I was supposed to tell y'all where I'm going to go with the show, but that's the plan. Now we hopefully will have to stick to that. So we were talking beforehand and kind of remembering where we left off. Thomas, we were talking that it's kind of ended with the verdict we talked about the first time, and then last time we talked a little bit about what's been going on afterwards and the investigation into the DA and any kind of things that he might have held back and not fully disclosed. Jessica, Thomas, y'all bring us up to where we are.
So if memory serves me correctly, we kind of ended with the discussion about him being brought to the grand jury. And please tell me if I forgot, but I think we discussed that ultimately the grand jury decided to take no action. And once that had concluded, what we were available to do, or what was available to us, was to do a public information act request, which we did. And we received documents that were related to the investigation into Clay. And just to kind of cut to the chase, what we found was, I think, and maybe Jessica can confirm, but I think it was more disturbing, and I think it angered us even more once we got to see the meat of what was actually going on behind the scenes that we didn't know.
So this is y'all investigating his investigation,
right?
The pro tem's investigation, yeah.
It's important to kind of point out here that when did we receive these, Thomas? Like it hasn't been that long. So it's a couple months we've had the documents, not even a month and a half.
No, not even. We got them early on in October. So
you got them like the day before the first show or the day of the first show?
Yeah. So that was the first time that we actually got full validation that what we had said was true. I mean, we of course got the validation of having the pro tem come in and do an investigation. But then, of course, it ended with, nothing going forward with the grand jury. But once we saw that, we put eyes on it. We finally had tangible proof that what we were saying was accurate all along. So I think there's something to be said there. It was kind of
definitely.
Yeah, it was nice, to know that it wasn't all for nothing.
For example, we got the smoking gun. We got a screenshot copy of the actual note that the investigator had input into their system that laid out exactly what Mr. Gordon, the complaining witness, had told the investigator when they went to go serve that subpoena. And in fact, I've got a copy of it. I can share the screen.
So this is when, back in first time we were talking about this, you're about to start jury selection. Clay comes over and says, "Oh, hey, I want to tell you something. I've been meaning to tell you something." The other guy says he was never shot. And this is like just the last of all the crazy stories about people who didn't see the third gunman and the, second shooter on the grassy knoll. And this is the comment. This is the note that generated that comment. Is that what you're saying?
Well, this is the note that the investigator put into their system, which is available to the prosecutor Clay, who was prosecuting the case. So he inputted that the day that statement was made to him.
Okay.
And this is what was never disclosed to us. And there's a date that this was inputted, and it was July 28th of 2022 which is several months before the trial, because the trial was in September, about mid-September.
Okay.
So this was the
Into-
information that the investigator had given Clay that he never told us. And then when he did tell us, misrepresented exactly what was told to him. And so this note is basically the key piece because it shows what the investigator learned. It shows what the investigator told Clayton. And it shows not only that he knew that information and had it well in advance of the trial, but that the disclosure, the half-assed disclosure that he made to us in the middle of jury selection was entirely inaccurate and misleading. So that's why I call it like the smoking gun.
And I would say on top of that, if we remember kind of, and it's been kind of a long story, but the in-chambers discussion with the judge, Clay, and us, where there was some justification trying to be made by Clay as to how this could have happened when the judge asked him point blank, are you going to let this go to a jury? You know, he kind of starts throwing the investigators under the bus. Not kind of, he did. I mean, he threw the investigators 100% under the bus. And from our perspective, we always knew that both the investigators were competent and good, and we didn't ever believe that could have been the case. So this note also kind of proves that the investigators did nothing wrong, despite what he wanted everybody to believe in that moment.
Right.
And so I have a portion of that. If we would like to share the screen, it's a short.
Sure.
I mean, it's like a little paragraph.
Yeah, man. If you got it, I'd love to see the smoking gun when we can. So rarely get to see them in this business.
So can y'all see that? Okay. So they did something kind of awkward where I guess it was highlighted. Is that okay?
Can you read it can you read it for those who can't?
Investigator on July 27th, 2022, contact was made with Kendrick Gordon while in custody at the Galveston County Jail. Gordon advised of the upcoming trial and presented with a subpoena. Gordon refused to accept the subpoena and advised that all that is water under the bridge. Gordon also advised that he, in parentheses, Smith, who was our client, didn't shoot anybody. Gordon was uncooperative in his contact with me, but the subpoena was provided to Corporal Prevost of the GCSO, which is the Galveston County Sheriff's Office, who was asked to place the document in preserved property. So,
dated July 28th.
2022.
Yeah.
And it says he did it the day before, so he put it in there. Okay.
And
pretty straightforward.
Smith
didn't shoot me.
Yep. Well,
okay.
Didn't shoot anybody,
Didn't shoot anybody. Statement. Yeah.
So that is, I mean, obviously, it's comical how different that is from I didn't get shot.
Right.
And what we later learned in the information that we got from the Public Information Act request was that the day that statement was made, investigator was training a new hire investigator. And when I say new hire, I want to qualify that a little bit. This was an individual who had been in law enforcement as a peace officer for a long time. So this was not like somebody green, fresh off the streets. The only thing that she was new at was just being an investigator for the DA's office. Fully trained.
Yeah, the DA's office doesn't hire people out of the academy, right? They hire people who have been who made their ways up usually to detective or investigator, if not higher, in other law enforcement agencies, and then 20 years later they go work for the district attorney's office. So
absolutely, and
new to the DA's office is not new to investigating crimes.
Correct. Just new to how this DA's office operates with their investigators and what they do, what their role is. So this is all information we learned from the PIA request, and essentially through both of the investigators' recorded statements, It's basically consistent, with the exception of one part that we'll get to in a minute. But essentially, he learned this information. He shared that with the investigator that he was kind of training and just kind of showing the ropes, basically, and said, this is a big deal. This is something we need to go tell Clay. We need to make him aware that the statement was made. And they walked over to his office and they told him exactly what it was. And Clay, it was like, oh, okay. And they said, would you like us to create a report? Do you want us to do like a supplement to the offense report? Do you want us to generate our own report? Should we give you a memo? And this is where there's a little bit of a deviation in both investigator statements. The quote, new hire investigator recalls it very specifically and very clearly. They told Clay about this information and he said, I'm not worried about it. I don't need anything. The other investigator, I think we talked about this or touched on it a little bit the last time, but it was, he could remember everything very clearly, very distinctly until it was something damaging for Clay. And then all of a sudden I can't recall. So that's a big deviation there.
Yeah.
And, but because I'm trying to respect their privacy, so I'm trying not to name names, even though I think in the screenshot I shared it inadvertently. But we'll call new hire investigator 2. Investigator 2 said, nope, 100%, without a doubt, this happened. This is what we told them. This is what his response was. Investigator 1 was dead certain on everything that happened except for one. He was specifically asked by the special prosecutor and his investigator, did Kendra Gordon say, I was never shot? When investigator 1 was asked that question, he couldn't recall if that's something that was said or not. When investigator 2 was asked that question, she said, absolutely not. That was not anything ever that investigator 1 told me. And I think that the proof is in the pudding because that is not documented in his note whatsoever.
Right.
The one that we just shared.
And what the quote, what the blurb shows is that's what the person writing it chose to put those few words in actual quotation marks, which anybody who studies, Western English literature understands literature, but that means like this is exactly what the person said, right?
Mm-hmm.
So they didn't say that he said, I wasn't shot. He said, Smith didn't shoot anybody. That's a huge thing. I mean, that makes, he's exactly what he's charged with doing, is shooting someone and killing them. And someone saying he didn't shoot anybody is
100%
a big deal. Yeah.
And I think that it's also important to note in that little blurb that he also quoted Mr. Gordon as saying, quote, all of that is water under the bridge. So
right.
He took the effort to quote that, put that in the note, which is not necessarily anything that changes the facts or the circumstances or what the trial, what his testimony would have been. Right. Like he's basically saying like, no harm, no foul, like we're fine.
Right.
If he took the time to document that type and that quality of a statement, if Mr. Gordon had ever said, I was never shot, I think it's evident from that he would have included that as well, but
right.
He didn't. And so it's omission from that note means that it was never stated.
I agree. I think it's a very we can make reasonable inferences. I think it's a reasonable inference is that you would write down something like that. I mean, right? You can see that that happening. Like, oh, it's water under the bridge. Okay, it never happened. Now, okay, I'm gonna write that down too. And then, he didn't shoot anybody.
Right.
So that middle one in there that would get written down. Like, even if you think this is an incredible statement that's being made to you, but
and. I think Jennifer can maybe, because she knows this investigator, personally from her experience at the DA's office, but this is not. He was a detective in the Major Crimes Division for Texas City PD for a long time, and he handled some of the most serious cases that this county's ever dealt with or had to deal with. So this was, his expertise and his level of experience. That would not be something that he would have omitted if that had ever been said to him.
Right.
Oh, I
Okay.
absolutely agree. Yeah. I worked with him for almost 20 years. So yeah, he is somebody that follows through with, his investigations and has done that throughout his career. So if it was something important, he would have absolutely put that in his notes.
So,
Okay. So where are we?
the-
So has the grand jury heard the case yet? I know the whole story, so I don't want to jump ahead. I'm bad about it.
No, and honestly, forgive me, I can't remember, but the grand jury, that process
talked
was
about
kind
that.
of, yeah.
They said no. They said no to the charges. Okay.
We don't know, of course. So, for those that don't know, grand jury proceedings, they're secret. Nobody really knows what's going on and what's exactly presented. We didn't really ask for that because I don't believe that it's discoverable under a Public Information Act request. But what I can tell you is this was my experience. We were in court that day when it was going to be presented to grand jury. It was one of the first cases presented at 9 a.m. We got information that Clayton was seen coming into the building with a big box, presumably
grand jury packet.
His grand jury packet. And we were made aware of that. And we also heard that he was personally escorted into the back into the DA's office. Where he sat, who knows? That's a level of access that we wouldn't have had. And it's also important to note that he has already been terminated at this point. So he's no longer even an employee. So we know that. And one of the things that Jessica and I both were very adamant about was we will testify. We want to testify. I believe that if either of us, you don't have to do both in a matter of efficiency, but if either one of us testifies, we're going to be able to do things like we just discussed with that note. We're going to be able to explain why an omission is significant. And we're going to be able to explain or put more context to why certain things didn't happen and why we know that that's either a falsity or like he's hiding things.
Right.
So Jessica and Mark had some important business that they had to deal with. So I ran down to the grand jury room. And when I arrived, it was about 9:10, 9:15 in the morning. So grand jury had started with this case for approximately 10 to 15 minutes. When I get down there, the pro tem was standing outside of the grand jury room. So I asked him, I was like, hey, when are we starting? What's going on? He goes, oh, we've already begun. Right now they're reading his grand jury packet. And I sat down and I said, okay, well, look, I'm here. I'm just going to sit here. I'm ready to testify. Jessica's upstairs. She's in court. She can come down in a moment's notice. We're here. Mm-hmm. So I asked him, what's going on since you're outside of the room and you're not presenting? And he goes, well, they're reading his grand jury packet. So to me, that kind of sets off a red flag. I'm texting Mark and Jessica. I'm like, he started with their grand jury packet. This is crazy. Why is he starting with that? Why isn't he laid out his case first and then say, okay, by the way, here's his grand jury packet? I mean, that's how I presented. That's how I was trained to do it. That's how a lot of prosecutors would present their case to a grand jury is you lay out your case first and then you give the defendant their word.
Well, I mean, that's how trials go too. We never let that's the state's burden. The state gets to go first. You lay out your case. You want your audience to know how you want the story perceived. But here, it's like he got the
He led
deference
with
yet
that.
again. Mhm.
Yeah, he led with
Mhm.
that, and that
Right.
I mean, to me, that kind of shocked me. And in fact, I talked to Jennifer about this after the fact, and I was like, I can't believe he did that. And she goes, well, actually, Jennifer, I'll let you tell that. I mean, it could have
Oh,
been
goodness.
strategic for him to do that.
Well,
So
I thought about
Jennifer
that.
Ott is,
Yeah, sorry.
you were the public integrity prosecutor for Galveston County for some time, right?
Yeah, so I actually worked at the Galveston DA's office for over 18 years. I was
Okay.
a chief felony prosecutor for 16 of those years. The last 5 years, I was the chief of the public integrity division. I left there in
Okay.
April of 2022, and now I'm doing criminal defense.
Okay. So, and what we learned last time, public integrity is, I think you investigate public officials, district attorneys, things like that.
Anybody that is working in the capacity of a public service, whether it be EMS, fire, public officials, mayors, police chiefs, all of those things. We are going to, if it happens on duty and you have committed a potential crime, then the public integrity division would be the person or the people that worked at that. I say person because I was a division of one, but
You're the bottom and the top.
I was.
I like it. That's how it is in solo practice too.
I'm not sure that sounded good, but okay.
Well, not that kind of bottom and top. I mean, y'all are the
never
ones that
mind.
went there. This is public
Sorry.
access TV. That starts after 11 p.m. Eastern. So yeah, so let me figure out how to get away from that.
Sorry. No, but what
No.
Thomas was saying
Squirrel.
was strategically.
Yeah.
He called me and he said, don't like the fact that they started with the grand jury packet. And I said, well, strategically, if I were presenting a case like this, and of course I still don't know everything they have in their part of their investigation, Thomas and Jessica, but I said, maybe it sounded so outlandish that, they presented that first so that they can then come in for the kill later. I mean, I hate to put it that way, but strategically, maybe it was something that the prosecutor thought, well, this is going to help us later on when I come in and show them all the things that is wrong with this statement or wrong with, the evidence that he tried to put forward.
Yeah.
Well, it might have been what did it because it ended up being going Clay's way. Did you ever get an answer on that, Thomas? Did you ever ask the pro tem on that?
No, we didn't.
That's fine. I was just curious.
Well, I mean, part of the reason was, and Jessica, help me refresh my memory, but I think how long did he present this case? It was not long.
Well, he thought it was going to take him initially days, remember? But if he started at 9, it would have taken them probably an hour to read the thing. I think it took him pretty long. And then I think they took a break and he was done before lunch.
Mm-hmm.
So I would say,
wow.
I don't know. Yeah.
2 hours. Days turned into like the morning before lunch.
Yeah.
We're talking about like hours, a couple of hours, not like an all day thing. Mm-hmm. And Jessica and I remember this very clearly. We went to the little common area, break room, whatever, in the courthouse, and we sat there waiting to get a phone call or a text message asking us to count. And we sat there for like 30 minutes or something like that.
It felt longer. Yeah, probably.
It did.
Despite our office being located directly across the street from the courthouse, and we could actually be there like within 5 minutes, but we wanted to be there in 5 seconds if we could.
Yeah. And eventually it got close enough to lunchtime.
Weren't y'all in the waiting room though? Sorry. Y'all were in the waiting room originally.
When I went down there and I bumped into the pro tem, that was in the waiting room, but I left. Okay. In fact, he asked me to leave. He said, I don't want the grand jury to see the two of us together and get an impression that the deck is stacked against Clay. So I left. I went back upstairs. We did some court stuff. And when we finished that, Jessica and I were sitting in that little common area. And it got close to lunch. We were like, they're going to break. Let's just go. So we go back to the office. It's literally across the street. And we start having lunch. It's all of us. It's our whole office, basically. And about halfway through lunch, the pro tem comes in and he goes, "Hey guys, I'm here. The grand jury decided to," or no, I think he started with, "Okay, my job is done. Grand jury decided to take no action." Gave us a document showing the no action. And he goes, "All right, you guys have a good day." Turned around and walked out.
Wow.
Well, that's not fair. He turned around and started to walk out. And I think Jessica said, "Well, like, did they say anything? Like, what happened?"
Yeah. I was
it?
like, I mean, he just starts
You
to
want me to
walk
validate
out.
your parking before you leave?
I'm like, nothing at all. And I'm like, did they say anything? Do we know why? I mean, come on, dude. And what did he
And what
say?
did he say?
He says something very unsatisfying. Like they had an issue with intent.
Yeah.
Which was always what we, from day one, we knew, from his own words that it was an issue of, first impression. Intent was going to be a problem. So, if I had to say what he was going to say, the issue was that's what I would have said, which who knows if the grand jury didn't get told that, we'll never know one way or the other.
That's what I was going to say. And let me, that's my take from it. I agree with you, but let me Jennifer has presented maybe 50 times more cases than I have. Mm-hmm. But my takeaway was a grand jury is only looking at the issue of intent unless they are directed by a prosecutor. And maybe Jennifer can add some. That's how I take it.
I mean, intent usually, when you're presenting a case to grand jury, you are pretty much, in most cases, presenting the bare bones of a case. I mean, we've got a million cases to present, and if they're just a simple less than a gram or something like that, it's just easy to give to the grand jury. If there's a situation where intent's going to be an issue, that's the time that you're explaining to the grand jury why this particular crime, why you believe that it was intentional. Because if you think they're going to have a question about it, you need to explain that to them, because they don't necessarily understand when you get in a courtroom how we actually prove that. So you cut it off at the pass.
So are you saying that maybe that there was like a discussion about an intent that wasn't necessary?
We have plenty of cases get indicted every single day of our own clients where intent is certainly an issue, and the grand jury never brought it up before. Of course, we don't know what this grand jury did. It's a pretty legally sophisticated thing for a grand jury to bring up. And not that you put people on the grand jury that don't know what they're doing or don't understand. It's certainly not the case. But for them to key in on the issue being, well, I don't know if they can prove intent beyond a reasonable doubt. I mean, that's pretty unlikely.
Well, in that respect, though, but in that respect, as a former prosecutor, having presented many cases, you are going to explain those situations to them. And if you believe intent was an issue, or for instance, if you think I cannot prove this case beyond a reasonable doubt because of intent, you probably might bring that up to the grand jury. I presented in my time a ton of officer involved shootings because of my position. And, all of them, luckily, were justified officer involved shootings. But I would have to explain that to them. Like, why is this justified? Where's the law? So those are obviously things that are going to take a lot more time. And I would also think in a public integrity realm that in abuse of official capacity or official oppression, if those were the charges that this pro tem was introducing to the grand jury, he was going to have to explain those things to them and explain to them, these are the things that I have a problem with. I don't know if we can prove this part.
But is a grand jury's job to decide if a case can be proven
No.
beyond a reasonable doubt, or is
No.
it just to
No, it's just probable
decide if there's
cause.
probable cause?
Right.
Mhm.
So if a grand, is there ever a time, I don't know, I've never presented a grand jury, but is there ever a time when a grand jury asks us to ask you something about like, well, can you prove this beyond a reasonable doubt? Can you prove the intent beyond a reasonable doubt that you've ever, what do you do? Do you say, whoa, it's not your job to decide that, it's just your job to say on probable cause, or how does that conversation go? I'm going a little bit different, but I'm just kind of curious.
No, you're fine. I think it can go either way. It depends. If you think that's going to be an issue for your case going forward, you may want to, depending on what type of case it is, you may want to hone in on, yeah, this is going to be difficult for us to prove. But you also have to remind them a lot of times that no, your job is only to decide whether or not probable cause.
Okay, so you do just
Yeah.
straight up tell them that. Okay.
Sometimes, I mean, being in front of a grand jury, it can, not that I'm saying that the prosecutors would sway anybody to do anything, but if you are going to have an issue later on down the road, like the self-defense issue, for instance, like I was saying with officer-involved shootings, you're going to
Mhm.
want to talk to them about that, because if you're just going by the letter of the law, then yes, there is probable cause that this officer shot and killed somebody, but at the same time, there is justification for it. So you also have to explain that to them.
Okay.
Yeah, and on that note, this was my experience. I always thought it was kind of funny, but you'll get some grand juries. They want to solve the case right then and there. Like, I mean, they want to ask questions. They're trying to be the ones that, like, we got it, we figured it out, we solved the riddle. Okay, go ahead. And you have to redirect them to say, look, your job is just to determine probable cause that this case should move forward. You're not here to kind of fill in the gaps that may not be there yet. Or, like, those are the issues for a trial jury to resolve, not you guys. Y'all are here to just say that there's enough to keep going. And I was
there wasn't even
which-
enough for this grand jury to keep going against Clay.
Right.
well,
Well, in their eyes,
I mean,
it's
it's
not knowing
interesting
what
that
they heard.
it's interesting though, because they didn't know Billet.
I was going to ask
And-
about that. So they said because you said he showed the document said take no action. So tell how that's different from a no bill, true bill, take no action.
I mean, honestly, Jennifer, I'll let you take that one. You can probably articulate that better than I could.
The way I always explain it to a grand jury, especially, I never dealt with no actions before I got into public integrity.
Okay.
But I always explained it to a grand jury that obviously a true bill is going to mean that you believe that there is probable cause to indict this person. A no bill is going to mean that somebody is arrested, has been arrested for the crime, and that you do not believe probable cause exists. Whereas a no action is more likely going to be your grand jury referrals and public integrity type cases where nobody has been arrested and nobody has been charged with anything at the moment. And so the grand jury does not believe a crime has occurred, and therefore they take no action.
There's no action to take. There's no bill
Right.
to take action on. There's no
Right.
true bill. Okay, that makes sense. I get that. Okay.
So
But they're rare. They're
I'm
rare
sorry,
in the sense that, I'm sorry, Thomas, but they're rare in
No,
the
no.
sense that they're only usually used in public integrity type cases.
Yeah, like you said, referrals and public integrities where there's not like an arrest, it's an investigation that your grand jury is conducting or someone's conducted and brought to the grand jury. Okay. Yeah, that was way better than Thomas could have explained that. Thank you, Victoria.
Well, I mean, like, selfishly, I take that as in they didn't exonerate him. They didn't say he didn't do anything wrong. They just said,
Right.
which is
They're just
which
taking no action.
Jennifer put it way more eloquent than my shoulder shrug.
Right.
But so moving forward a little bit, my favorite part about this whole thing and the information and the documents that we got was Clayton Harrell's written statement. And I'm looking down because I'm looking at it. It's 4 pages, single space. And my
A
favorite
lot
part
of
about
explaining. It's a lot of explaining
is.
to just like one little thing, right?
I'm going to hold this up. I don't know if you'll be able to see it. My favorite part about it is this.
Throughout this statement, I continually refer to Kendrick Gordon as Kendrick Coleman by mistake.
So
Nice.
it's dated, and we've got this 4-page single space statement where he couldn't even
Where
get the defendant's
Every
name
time
right.
he says Gordon, he means
Or
Coleman,
not the defendant's. Yeah, basically.
Witness.
and he can't do find and replace.
Well, there's this
Talk about
funny moment
favorite
because there's
function.
on top of this 4 or 5 page statement, there's also like an hour and a half, 2-hour audio interview. And at the very end, the investigator for the pro tem, essentially it was that's my favorite moment in all of this, because he calls Clay out and he says, like, so, you want us to kind of believe XYZ, and you want us to believe this was a big moment, and you went back and you referred to your notes, but it feels a little disingenuous because the entire time we've been talking, and in this entire written statement, you have referred to Kendrick Gordon as Kendrick Coleman. Do you understand why that looks really bad for you? And then Clay tries to explain himself, and then the investigator jumps in and he's like, listen, guy, how's your wife doing? Is she doing good? I'm glad to hear that. How are the kids? Are they good?
Yes.
I'm sure you're a really nice guy. I appreciate all of this. I just wanted to point that out. I hope you have a good day. Just real.
Nice.
Just,
Wow.
Oh, it was such a good moment. Such a good
Man.
I
moment.
mean,
So
because
that's what stemmed him writing that in there.
Man, that is
That's
just like some
also-
big egg on your face. That is a
Well,
classy
'cause
way to
that-
show that too.
that also ties into, like, probably tied for my second most favorite. So throughout this 4-page statement, he blames every single person under the sun except for himself.
Yep.
He blames Judge Robinson. He says that Judge Robinson made promises to him that he didn't live up to. He blames his court partner for
Being
who was covering
inexperienced.
for him, for being inexperienced, for covering for him when he couldn't be there. He blames the investigator number 2 for having no experience whatsoever. He made her out to look like she had circumvented part of the police academy and just kind of showed up on the DA's door and they took her in like a
Wow.
wet dog.
Wow.
He blames
Which, can I
investigator
just
number
say
1.
this?
Yeah.
That investigator has been with the Galveston County Sheriff's Office for almost 20 years, if not longer. And she was the head of the jail. She's very smart and knows exactly what she's doing.
Respected by both sides.
Everyone.
Oh,
Mm-hmm.
and after listening to her statement and how she conducted herself in this whole issue, I don't know that there's anybody that I respect more than her right now in law enforcement and in this county.
Yeah.
But my favorite part is that Clayton really relied very heavily in the first 2 pages of the statement. He's discussing that his wife had this emergency, this big cancer scare. And I don't want to sound like an asshole. Like, I mean, that's a scary thing. And that may have actually been going on. And when he was telling us, when he told the judge, and when we heard some of the mutterings and the rumors going around the courtroom, it was Clayton's been under so much pressure. His wife is having this horrible cancer scare. And this was before, I think, conceivably the written statement had been made, but he put this wonderful little tidbit in his written statement that I had a problem with. But I also find it kind of comical. That makes me sound like a dick. I'm not laughing at anybody facing a cancer scare. Respectfully, I mean that's got to be terrifying. What I'm trying to point out is he relied so heavily on that, and he said, "My wife is facing cancer," but then he puts this portion. My wife had surgery on August 29th to investigate the potential threat of cervical and or uterine cancer. Everything seemed to go well. She went back on August 30th, 2022, the very next day, and had an elective cosmetic procedure performed. She did this so that she would not have to take off work a second time because the recovery time from the exploratory surgery was the same as the recovery time for the cosmetic procedure. So this is why I like that. This is why this kind of makes me laugh a little bit. Is he presents and he's representing to everybody that something happened. It was an emergent situation. We had to drop everything to deal with this, and we were so terrified.
Schedule the cancer screenings.
Right. And this is part of the reason that I failed to disclose this critical information. Which is a very sympathetic thing. You would understand that. I mean, if my
But by the
wife,
following day, you're already learning that everything went fine and we're going into a cosmetic surgery.
Well,
so it's a little disingenuous to continue to state that when it seems like it was pretty quickly cleared up. I think.
Well, and there's also like an inherent thing if you're getting cosmetic surgery that you kind of think that there's some longevity that's going on, right? It's an investment in the future.
Correct.
Well,
so
and not
I don't
only
know.
that, but I mean, I have not had cosmetic surgery, but I will tell you that, well, I would suspect that I could not call a plastic surgeon right now and say, "Hey, can I have a surgery tomorrow or 2 days from now?" And they say, "Yeah, okay, yeah, we'll squeeze you in." And the reason that's significant to me is that those two things, either this was an emergency that you had to drop everything to take care of, or this was not. Like, those things are mutually exclusive. You can't have an emergency that has to like drop everything, we do this exploration, and at the exact same time you're able to schedule and coordinate a cosmetic procedure to coincide with it. I would imagine that
There's
cosmetic procedure
scheduling
takes
and
months.
coordination.
Correct.
Oh, Jennifer.
I'm sorry, but the thing so that was in August, right? The end of August that happened?
Yep.
The disclosure was made to the investigator in late July.
July 28th.
So
July 28th.
as a former prosecutor, if somebody came to me, if an investigator came to me and said, "Hey, I know this is not a big case, like let's say it's a less than a gram or something like that, but I talked to this witness that said that wasn't that guy's dope," right? I'm making it as simplistic as possible.
Yeah, I
The
love
first thing I'm going to do is go, "Okay, that's not good for my case. Let me go let the defense attorney know about it." Even if I felt like that's BS and I know I can discredit this witness, I'm not worried about it. You're going to immediately call the defense attorney or email them, however you want to do it. But something as big as a murder case and the other victim, it's a murder, ag assault, and the other victim tells you that that's not the guy that shot me, that would make the hair on the back of my neck stand up as a prosecutor. I would absolutely have had a pit in my stomach And that's what you're taught for many, many years. You're taught that at baby prosecutor school. You get that pit in your stomach, then there's something wrong, right? So in that situation, I can't imagine not immediately picking up the phone. And of course, that's me. I'm not every prosecutor. Prosecutors do their own thing, but it definitely would have been weighing heavily on me that I have this information. And even if it took me, because I was in trial or whatever on another case, took me a week to get back to the defense attorney and let them know there's no way in the world that you would not disclose that.
So the operation his wife was the operations she was having 4 weeks later shouldn't have had any bearing because he should have notified y'all Thomas and Mark and Jessica right away. Is that what you're saying,
Yeah,
Jennifer?
exactly.
I mean, if you're doing your job and you're seeking justice, which is the oath that you give, and you take, then absolutely. Even if you thought I can completely discredit this witness. I mean,
Right.
Justin, when I was a prosecutor, if I met with a witness and they said the offense report said that the person's hoodie was black, and the witness came in and said, you know what, it was actually navy blue, I was sending an email saying, hey, just FYI, because even though it has no significance in the case, it was something different that the witness said.
Sure.
So,
And here's what it comes down to too, because Clay knew it was disclosure worthy with what, if you want to believe what he wants you to believe, then when he heard that statement, he heard, oh, I wasn't shot, or the guy wasn't shot at all. That's crazy. Not really a big deal compared to he didn't shoot me. But it was a big deal because before Bordier or after Bordier, when he comes up to us and he says, hey, ha ha ha, this is what the guy said, I'm going to get y'all a disclosure. We never got that disclosure, the written disclosure, all throughout trial. So in that moment,
Well, until he knew we were calling him.
right. In that moment, he knew from his own words that it was disclosure worthy. So from the moment in time in July, when he heard that from the investigators, whether he read it or not, he knew what he should have been doing and he didn't do it. And then he brought it up to us at the first day of trial and he still continued not to do it. So, I mean, it doesn't get any more bare bones than that. I mean, it's just complete lack of integrity there.
Well,
and I'm sorry, Justin, but just to piggyback on that just for a second, the reason that I kind of put the emphasis on the pro tem starting with his grand jury packet, they didn't keep a copy of it. We don't know what that grand jury packet says, but in the same context, we can make inferences. It's reasonable to assume that it is very similar, if not identical, to what his written statement is. And when you read it and the emphasis that he puts on the surgery and what he was going through with his wife, it makes him appear very, very, very sympathetic. And it's no confusion that if they read that first and went into the rest of the presentation, that they would be somewhat favorable and excusing of his conduct and take no action. So that's why that's so significant to me.
Yeah, I think that's an easy play if you have like so little integrity that you will do to your client what he did to him, try to, take this man's freedom away for the rest of his life and let an actual murderer go free, then you will have no problem like milking whatever I'm sure was a stressful thing that his wife and he were going through and everyone in their family was going through, but like just embellishing it and making it, an emergency thing that is the reason for this huge lapse in judgment that I guess he's even acknowledging is a lapse in judgment, right? That's why he's got all these excuses for why he had the lapse in judgment.
It was everybody's fault but his.
Here's one thing though. I hear what y'all are saying. But what if it's worse than that, right? What if, because what he said to you, right, Jessica and Thomas, was that, he said that he didn't get shot, right? So you think about it for a second, if in Clay's mind, Mr. Smith is the guy, and this guy's saying Mr. Smith didn't shoot anybody, then in Clay's mind, that guy's saying the same thing as I didn't get shot. Right? Because if Mr. Smith didn't shoot anybody, then no, then you didn't get shot. Right? Is that
I
what
never
you're
thought of
saying?
that.
So maybe that's his way of telling you this.
Wow.
And he can't now
It
go
is.
back later and say, wait, I was playing word games. Okay, I did tell him. I just told him that, like, he must not have gotten shot because he's saying Mr. Smith didn't shoot anybody.
Yeah, but
Well,
And he now
that
his
is-
ass is in a sling and he can't go and tell anybody that. So now he's got to start digging deeper.
Well, here's
Right?
something funny. No,
I don't
here's
know. I
something
don't know
that's-
Clay.
I like
There's my
it, yeah.
disclaimer.
Oh, no,
I don't
no.
know Clay, so I'm making a lot of assumptions about a total stranger. But I think
Sounds
you're
like you
pronouncing
know
his
him
last name.
from that. Yeah.
But
it
I
sounds
think you're
like
kind of
you know
spot
him.
on, and I think Jessica can probably speak to this because I know we're running out of time, but kind of quickly. At one point during his recorded statement, this was not in the written, but at one point he starts talking about, "Oh, I don't hear very well."
Oh yeah. Oh my God.
yeah.
It made me sick to my
Jessica,
stomach.
tell him about that. Tell him about that.
Yeah, amongst the other reasons for why this happened, he on top of that says, and of course we have another instance where the investigator pipes up and says something kind of smart to it, which is also another good moment. But he says, "But keep in mind, guys, that I've got terrible hearing." And when they were talking to me, I rely a lot on watching people's mouths move when they talk and reading their lips, and watching their gestures. So I may not have heard them correctly. And so the investigator says in response, "Okay, so now we're saying that she can't hear." Okay.
Okay.
And we move on from that. I mean, are you kidding? If you can't hear, then go read the note that was left.
Right.
Go
That's what I'm
read
gonna say. Like,
well,
it's in
and-
quotation marks.
well,
Go,
the thing
Jennifer.
is this, I'm going to go ahead and say this. I was terrible at reading notes, and honestly, that's the system they use. But I absolutely can say, even bad hearing or whatever, I know both of these investigators. I have worked with them for 20 years, and it was a big enough deal for them to stop him and say, "Hey, FYI, this is what this guy said," and then to go in and make notes about it. At some point, you obviously have to realize this is a big deal. If I've got two investigators coming to tell me, "Hey, we may need to take this guy's statement or write a report." Very rarely do investigators in the DA's office write reports. When they have to write a report and come to me to tell me, "Hey, do you need me to follow up on this and write a report or interview this person?" I mean, public
It's a big
integrity is
deal.
different, obviously, because my investigator did everything for me. But in a normal case, your investigators are your detectives from whatever agency you're dealing with. So if they are going to, if your DA investigators coming to you saying, "Hey, I think you might need to follow up on this," that's definitely something that would make you kind of go, "Okay, well," even if you would say, "Let me call the detective and tell him to follow up with it."
And remember, he did need to be followed up with because of what he told me in the jail cell. He gave, when I asked him why, how do you know, which is the natural question that you ask as an investigator when someone makes a conclusory statement, right? Why do you feel that way? What gives you that reason? He said, "Because your client is a light-skinned black male, and the guy that shot me was a dark-skinned black male. The other guy that we had pointed the finger at the entire trial was a dark-skinned black male. Our client was very much light-skinned." And so it was like that, the aha moment that we keep talking about. I mean, he needed followed up with. Somebody needed to go talk to him, and it shouldn't have been my job. Thank God for our client that it was, but it shouldn't have been the defense.
He gave an articulable fact to support his statement. It wasn't just, he didn't shoot me and then left it at that.
So we only have I'm sorry to cut you off, Thomas. We only have 3 minutes left. We've been talking about this show, this story for almost 3 hours now, and I really appreciate y'all doing that. I wanted to have a little bit more time to talk about this, and I want Jennifer to maybe, if she has any insight on this, but this is a really open-ended question that's kind of
Okay.
charged. But so anybody jump in with whatever you want in the less than 3 minutes we have left. But why do you think Clay did this? I mean, do you buy? I mean, obviously you don't buy the bad hearing, the emergency operation, the other things that it's everybody else's fault. But why do you think he did this? And Jennifer, maybe more broadly, in a very short period of time, why do prosecutors, or I don't say public officials, because we're talking more about prosecutorial misconduct.
Yeah.
If you investigated that kind of thing, what happens? Why do they do this?
Honestly, Justin, this is the first time in my 20-year career that I've actually seen a prosecutor do something like this. Prosecutors, I'm not saying that hasn't happened, but I can say that something this blatant to me was very concerning. I can also say that, yes, things sometimes slip through the cracks, but you also have to have, if you have the integrity behind you and a good relationship with the defense bar and that sort of thing, if you show up with a video on the day of trial, maybe it's not as bad, right? As it's going to be if that's what you're doing every single time. But something like this, I honestly have never seen in my career. Thank goodness. I hope it's not something that we see all the time, because that's scary. And it's, I loved my job. I thought it was wonderful. And, but I took my integrity and I took the fact that there is somebody's life on the line very seriously. Even when
that's the important thing. You take the power that you have
it's a huge power. It's one of the biggest powers that somebody can have. You're taking somebody's liberty away.
I'll say here real quickly, here's the scariest answer to your question, Justin. And we'll never know why he did what he did. But this is the answer that I lose sleep at night over, because he had done it before and it worked in the past, and it just wasn't caught. And that's the scariest thing. And we don't know.
The only reason it's caught was because a diligent, experienced, good investigator decided to document it. But I mean, if this had been a conversation that Clay had with him, independent of anybody else, we may have never discovered this.
Well, and he got caught, but then he got to keep the job a year after he got caught, a year after his boss was told that he got caught.
That's a whole nother podcast, Justin.
Yeah, that's a different
whole nother
episode.
Facebook Live.
A different episode.
Yeah, so we're getting the wrap sign from Mark Pirtle, but this I appreciate you guys coming on. This is an incredible topic, and I would like to be able to draw on y'all's experiences with the broader topic in the future. But thanks very much. We're going to get shut down. But y'all will stay tuned and hear more about this story. Please let me know how it goes. On behalf of Harris County Criminal Lawyers Association and Houston Media Source and everybody at Reasonable Doubt, thank you all for coming on. Thanks everybody for watching. Mark Pirtle, you rule us. Thank you.
Thank you, guys.